Hi everybody, this is Jason Lindamood with the Lindamood Law Firm, where we focus on estate planning and probate. And today I'd like to talk briefly about the benefits of a revocable living trust. But first, if you would like to talk to me about any estate planning or probate issues, feel free to contact us by going to estateplaninfo.com. That's estateplaninfo.com. I've had a number of conversations lately with clients who have asked initially about the benefits of a living trust as opposed to a last will and testament. And while I really like wills, there are definitely some benefits to a living trust that you may want to explore. And it may not be for everybody, but in this video, I'd like to at least go over a few factors that seem to be a common thread amongst many of my clients who decide to go the route of a revocable living trust. So here are a few things to maybe consider. First, we are able to avoid probate, and that's a big one. And that's typically one of the big ones that clients are trying to achieve by going the route of using a living trust versus a will. If we create a living trust and do it the right way, most of the time our loved ones won't have to hire a probate lawyer if something were to ever happen to us. Next, our beneficiaries don't have to wait a few months to get our assets retitled into their names while probate is still continuing. Another benefit of a living trust is that when we die, we don't have to worry about the government or the court system controlling how our property is being distributed to our beneficiaries. So in essence, we maintain control rather than giving some of that control up, at least temporarily, to the courts. And us maintaining control by making our wishes known within the terms of a trust keeps us out of the court system. And that's a good thing in most cases. Not all cases, but most cases. Something else to think about is that in many wills, in many last will and testament, if something were to happen to us, and let's say we have kids who are younger, whether they be adolescents or older teenagers, one of the not so great things that we can do is to leave a fairly significant lump sum of money to a child or a grandchild who may not be quite capable of handling an inheritance of a significant amount, which is what can happen if there's no language in the will to prevent it. And when our minor children turn 18, they automatically get an outright distribution, which may not be the wisest decision. Or even if they're older than age 18, let's say they are 22 or 23 years old, for sake of argument, we still may want to avoid a lump sum distribution to them in order to give them some financial protection, as well as stretching that money out through the course of their adult life as they get older, and maybe even into their adulthood, depending on how good they are with managing money and other factors that are probably situation specific, so to speak. So if we don't have anything in place that staggers out the distributions of our assets over a period of time, or maybe staggers them out at several different stages of their lives, then that's the problem we're probably going to have. And from personal experience, I really didn't know nearly as much as I thought I did when I was an 18-year-old young man. And if I had a lump sum of money coming at me at that point, in my late teens, or even probably throughout most of my early to mid 20s, now that I think about it, chances are I probably would not have made the wisest of financial decisions. Let's put it that way. So that's something to consider whenever we're thinking about a trust that can help us guard against that sudden windfall that we may not even be considering when we're drafting a typical will, unless we make specific provisions to guard against it, which is possible. We can do that in a will. Another thing that comes to mind is that a trust can help us avoid estate tax issues if the proper planning is put in place. And in reality, This only comes into play if we have an extremely large taxable estate. And right now there's a federal estate tax exemption of around $11.7 million per person as we sit here in 2021. And although we think Congress is probably going to lower that significantly, and if we're married, we basically double that and double those numbers. So unless we are doing really, really, really well financially, which is a blessing and a great situation to be in and not a bad problem to have, then most of us probably won't have to stare down the barrel of that estate tax gun, so to speak. But if we do draft a living trust, that can also help us avoid some of those estate taxes because of some portability issues that living trusts provide and allow for, in terms of allowing our spouse to acquire all of our assets if we were to pass away without triggering an estate tax event. And if you're like me, we want to be wise in our thought process so we don't have to pay the current 40% tax rate for anything above and beyond that threshold amount. And again, the threshold amount's high. It's like 11.7 million right now. So it's probably not going to come into play for most of us, but it's something worth mentioning just in case it does. Another benefit is that if we leave everything to our children in a trust, we can structure it in such a way that we can help make our children's inheritance, again, for lack of a better term, divorce-proof. Let me explain that for a moment. Assuming we do it the right way and draft the language properly in a trust for our child, the assets that they get from us won't be mixed up with, or to use a legal term, commingled with the monies or the assets that our child has acquired jointly with their spouse. So if we keep everything separate and our child were to get divorced, they'll get to keep the inheritance trust assets because it hasn't been mixed in or, again the legal term, commingled with their spouse's assets. In other words, it's traceable and it can be looked at as our child's separate property by the courts, and that's important. That means they get to keep what we left them without worrying about any loss of assets if an unfortunate situation such as a divorce were to happen. There are probably a few more reasons why people may want to look into or use trusts as sort of the nucleus or foundation whenever they're developing their estate plan. But I'll talk about those in another video because that's all I can think of at this moment. So that's all I have for you today. Once again, if you have any estate planning or probate issues that you'd like to discuss, head on over to estateplaninfo.com. That'll take you to our website where you can schedule time for you and I to speak about those issues. And once again, I'm Jason Lindamood with the Lindamood Law Firm. Thank you for your time. Thank you for watching, and I'll talk to you again soon.